Okay, so look, we're going to be very, very brief because, as our incredible colleague Christy O'Connor said, there's not a lot to actually say given the thoroughness of His Honor's analysis of everything that was filed. So the docket really speaks for itself. There was incredible filings and briefings done, and such a great job by Ms. O'Connor. And so we appreciate the fact that His Honor, it was one of those days that makes it so rewarding to be a trial attorney when a judge takes everything that was submitted and goes through it so thoroughly and in such great detail. And so I'll ask you that was in the courtroom and then have read the filings to rely on His Honor's questions today and the points that he made. And as you, but most importantly, as our innocent client, Durk Banks, and I emphasize, our innocent client, Durk Banks, is waiting. We are looking forward to the close of business today when we get this order, so that we can see if we can be at this courthouse on August 20th, 2026 for the trial that we've been working on and preparing for 22 months. So we appreciate you all being here today. We're super excited for His Honor's order to come out today, and we so appreciate the thoroughness that took place in that courtroom today. So with that being said, we're not going to do any questions. We appreciate everybody who's here today. Thank you.
Appreciate you.
Did the high five and everything because Drew and Brian knew that Christy had wrote something dope. But let's take you to the beginning of the day. And if you say based off what Mel was doing, you was going to call it, then you called it right. Well, that was a very intense hearing. Judge Fitzgerald was expressly not happy with the filing of this third indictment. He plans to issue ruling by EOD on if counts 1 and 6 will be severed. EOD meaning end of the day. So she says, at one point, judge told government, you have yet to give me a good reason as to why I should not sever these counts, and I am inviting you to do so. A few minutes later, judge said, please try again and tell me concretely why I should not sever these counts. Judge articulated that the filing of this third indictment was close to trial is unfair to the defendants. That unfair word is very big in law. Masterfully big. And he questioned if the Chicago incident is so inextricably intertwined to the case, why the government didn't press him on it months ago when it was first brought up. You've had months, over a year, to argue what you need to prove this case. You chose to exercise strategy and belatedly decided to bring this indictment. Judge asks if the government has asked Miss Robinson, victim's mother, what she thinks about the trial being delayed because of the added charges. Government requested they be allowed to submit a written response to today's hearing immediately after court. And we'll ask Miss Robinson her thoughts, then include what she says in the filing. Judge replied, please stop presuming I will or will not do something. AKA the judge isn't letting them submit the response. Oh, shit. So the judge's like, hey, bro, I don't give a damn about y'all lagging y'all nuts. I'm still going to do what I'm about to do. When Christy O'Connor got up to give argument on Durk's behalf, she basically said, Your Honor, you said it all. I don't have much to add. Bruh, what? Y'all know she's the one that wrote the damn, what's the name? It wasn't Drew and it wasn't Brian Steele. She wrote that 19-page goddamn motion, in case you didn't know. It was Christy O'Connell. Y'all can look up her writing style and how she argues shit. That ain't nothing but Christy. Shout out to her. She did eventually add that from the beginning, Durk has requested a speedy trial, and any further delay because of the government's actions is unfair to him. They are requesting the August 20th date remain on the calendar for counts 2 through 4, and another trial date be set for the added counts. Meaning, we'll fight this shit at another time, but more than likely, they're not going to have to fight it anyways because the feds in Illinois said they didn't have enough any goddamn ways. Okay, last note, pardon me. The government is relying on established case law that defendants' trials should not be severed unless there is a clear prejudice against defendants, especially a conspiracy case. Judge made interesting remarks about that case law being about defendants being severed versus counts being severed. He asked if there's anything to support why counts shouldn't be severed. Government's position, the case law applies to both. I might look into that because I don't believe that. I believe what the judge believes. that the counts actually be severed and not that shit. It's basically said if you can't sever certain things, aka people, then we'll sever the details about what the hell you're talking about. And I don't believe case law actually supports what the feds are arguing. But shout out to Fitzgerald though. So of course, you know from the title what happened, right? Okay. Roll it. Man, golly. So, date, July 14, 2026. Interpreter, non-applicable. Rita Sanchez. Proceedings in chambers. Order granted defendant Dirk Banks' motion to sever counts 446, 459. Denying defendants Wilson and Lindsay's motion to sever defendants 430. Further notice, retrial. Notice how we're not seeing a grant anywhere? I'm wondering. Before the court are the following motions. Defendant Dirk Banks filed a motion to sever counts or, in the alternative, to dismiss the motion to sever counts on June 29, 2026. Docket numbers 446, 459. Defendants DeAndre Dontrell Wilson and David Brian Lindsay filed joinders to the motion on June 30, 2026. Docket numbers 453 and 454. The government filed an opposition on July 6, 2026. The defendant Banks replied a motion on July 10, 2026. The government filed a supplement to its opposition on July 13, 2026. Defendants Wilson and Lindsay filed a renewal motion to sever on June 10, 2026. Shout out to, 6 times 10. Government minutes, general. Government filed an opposition on June 17, 2026. Defendants Wilson and Lindsay filed a reply on June 24, 2026. Court held hearings on July 1st, 2026 and July 14th, aka today. The motion to sever counts is granted. Counts 1 and 6 are severed from counts 2, 3, 4, and 5 in the third superseding indictment. Trial on counts 2, 3, 4, and 5 will proceed on August 20th, 2026 at 8:30 p.m. a.m. The court exercises its undoubted discretion for the reasons argued in the motion to sever counts and discussed at the hearing. In particular, the clarity of issues for the jurors in the Los Angeles trial outweighs the inconvenience to the second set of jurors in the Vicar trial. It has been and remains the court's intention that the Los Angeles trial will include all admissible evidence that is not unduly prejudicial under Rule 403. Therefore, the government cannot be prejudiced by severance. The government chose to withdraw evidence of the Chicago incident in Los Angeles trial for the reasons expressed in the prior order denying severance. The renewed motion to sever defendants is denied. As to the Los Angeles trial on August 20th, 2026, in other words, defendant Banks, Wilson, and Lindsay will be tried together on counts 2, 3, 4, and 5 of the TSI on August 20th, 2026 at 8:30 a.m. The trial will proceed every day from Monday to Friday from 8:30 a.m. to 4:30 p.m. And it's intention of the court to, employ a questionnaire for potential jurors. Counsel should meet and confer about what questions would be appropriate at a future hearing. The court will discuss with counsel the content of the questionnaire and the precise procedure for using it with potential jurors. The court further notes that defendants have not been arraigned on the TSI. That arraignment should take place promptly before a magistrate judge or at the next hearing before this court. Counsel should meet and confer to establish a trial date on counts 1 and 6 of the TSI. It is so ordered. But Nash, what were the original counts? Well, the 1 and the 6. The 1 and the 6 were the RICO, basically, and the Vicar. But let me read it correctly. Count 2, use of interstate commerce facilities to commit murder for hire resulting in death. Count 3, stalking resulting in death. Count 4, using, carrying, and discharging a firearm during a crime of violence resulting in death. Count 5, conspiracy to use, carry, and discharge firearms during a crime of violence. All righty, we got that part. And then you want counts 2 through 5, right? So count 1 was racketeering conspiracy, basically RICO conspiracy involving the alleged Banks gang enterprise. This is the broad conspiracy count that incorporates the newly added allegations, including the Chicago murder and Atlanta shooting allegations as part of an alleged enterprise. And then count 6 is violent crime in aid of racketeering, Vicar, tied to the alleged Atlanta shooting that the government added in the third superseding indictment. This was one of the new enterprise-based charges added shortly before the trial. Okay. So now y'all have it all. And I have some dope lawyer people who are pretty amazing. So if this lawyer wants to step up in the comments, then cool. But here's what she said. I don't want to put it up on there, but I'll try to do it this way. She said, well, Banks argued in how the government responded. Durk Banks asked the judge to split the case into two. The third superseding indictment filed June 3rd, 2026, added the most serious charges in the case, including the Vicar murder count 1, and related machine gun count 6. Banks' position laid out in his reply, that was the government dropped these heavy new charges roughly 11 weeks. Blah, 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 blah. I laid it that, baby, but yeah, I kind of already covered these. But what she goes on to say, the judge separately denied all that. But what sucks for him, I guess, is even if found not guilty of murder for hire, still going to be in jail, no bond to the next trial. But not to have two murder for hires talked about in one trial definitely helps. Yeah. Nash, what do you think? I think he's going to beat it. The Chicago shit, that the feds in Chicago named him and then said we don't have enough to essentially prosecute him. And like Drew, well, technically, like Christy O'Connell said, the damn quote-unquote snitches in that case, the two guys who did it, they won't be testifying that Durk paid them. So you're going to have to testify what? That somebody else paid you in particular, and then that person is going to have to prove that they, what? Paid them? So why isn't that person arrested? Because that doesn't make any damn sense. You can't sit up here. Hold on, we're missing my light. My bad. There we go. You can't sit up here and say, yo, these two guys, they killed somebody for some money, but, you know, the money, honey, the funny money, it got paid for by him. So is him arrested too for murder for hire? Because you can't walk out of that. Snitches don't get away free. They typically got to tell so much that it brings down empires. So now I'm curious, who's the third person arrested? So I'll be curious to see what Trap Lord Ross and what Flacco are going to say, because I guess y'all can't write the Lil Durk is cooked shit until the trial happens technically next month. So we shall see. But when y'all holler money, 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 and billion-dollar lawyers and all this shit and everything, this is what you get, a little bang for your buck. It's not necessarily always, and like we said with the YNW Melly trial, it's not always that the head lawyer is the one that's doing the heavy lifting. It's typically nice to have a dope-ass team that thinks outside of it. Carrie Hall, she gonna spank the shit out of the state of Florida when it comes down to the YNW Melly trial. She's going to give the best fight that we're going to see. Drew is in on it. Don't get me wrong. Drew's going to do his shit, but it's going to be Carrie who does it. Maybe we can say it's typically women in law who do everything right. I don't know, because shit, I'm biased as hell. Y'all know who my favorite lawyer is down there in Atlanta. Y'all know, but she's married, so I don't want to say her goddamn name. But if I need to, then y'all, if you know who it is, you know who it is. But now, on a serious note, this is a win for Durk. They're going to trial, but it could be a L. They might not need that Chicago shit. But I would ask you this. If they don't need it, then why the hell did they bring it up in the first place? Things that make you wonder, right? Made me wonder too. But hey, subscribe, turn on bell to notified, share to keep your people aware. People saying I don't got the PlayStation? I guess. PlayStation right there. The Xbox is right there. If y'all want to see this shit, just let me know. I'll put them right there and right there. But hey, 10K away from the giveaway. Technically 9K away from the giveaway. We're like 50 subs away. So there you go. But we got that update, and we got a major update dropping soon. So I will catch y'all in the next one. Until then, click right here to see how the fans said, Pooh Sicey Daddy, you full of shit, but you can waste your gas. Click right here to see what the hell they talking about, or click right here for the playlist, and I will catch y'all in the next one.